Welcome to USA Global TV and Radio, where our mission is to provide education, entertainment, hope, and inspiration. USA Global TV and Radio connects you with experts and audiences all around the world every single day to help you succeed in business and to live a richer life. Visit us at USAGlobalTV.com to learn about career and life-changing training and mentoring programs like the Listening Mentor. Subscribe to our newsletter to stay informed about our special programs and offers. Discover how you can become a guest on one of our shows or a host or producer of a USA Global TV and Radio show of your very own. That's USA Global TV and Radio, where the doctor is always in.
Hi, red.olaughlin here, the wise one today on the USA Global TV and Radio Network. And I'm super happy today to have somebody on the show that I've been wanting to have on for a long time. Larry Rosenthal is an intellectual property lawyer. And we've had lawyers on before, and we try to talk a little bit about certain things. I'm an author, and I have a lot of clients that I work with who are writing books and getting things published. And there's always those questions that come up about copyrights and this and that and whatever else. And that's just one small fragment of the entire intellectual property legal business. So we're going to get into that very, very quickly. So Larry, please join me.
Thanks, Red.
Larry and I met through a networking event not long ago, and he said, okay, IP attorney, and I knew what that was. And it's one of those things that we had a conversation and we kind of ended up in everything but the IP arena. And I thought he'd be a great guest today. But tell us very quickly, what actually is intellectual property?
So intellectual property, or IP for short, is contrast that with real property, which houses and buildings. Intellectual property is the inventions, things that exist in your mind. Generally, like ideas or inventions. Okay, so
but that's something you've only been in the last 10 or so years, if I remember right in our conversation. I could be wrong about that, but it's something, it's an after career kind of thing. Is that a fair statement?
That's correct. I've been doing this since 2007 when I graduated from law school. But before that, I was an engineer. And then after getting into law, it was really a good fit for my background to get into the intellectual property side, because to be a patent attorney, it's very useful and sometimes required to have some sort of engineering or science background.
Now, you were a quality engineer, is that right?
Yes. Okay. Software quality and then software engineer. Yes. Okay.
I was a quality engineer for a number of years, and so there's a little bit of affinity, and I understand what you're going through. You were in the software end of things. I was in the manufacturing portion of it, but I was also involved in a couple other aspects. So, but regardless, it's a good understanding of what's there and how things work. And so I can easily see somebody with that kind of background having a legal understanding of, okay, this is the intellectual property and this is the way it works. And yes, they all match together. Tell me about one of the more intriguing cases you ever had with trying to get a patent.
Trying to get a patent. So there are so many different things you can do with intellectual property. So on the patent side or trademark side or even copyright side, there's the obtaining the rights. That's what you just referred to as getting the patent. There's also the asserting the rights or defending the rights against other companies if you're being sued or you're going to sue somebody else once you have those rights. So getting the patent, that's not the most exciting thing to talk about. The exciting cases are in the disputes. But sometimes getting the patent can be interesting if, well, can it be interesting? What I find interesting about gaining patents is learning about new technology, new inventions that people are coming up with. So sometimes you think an area is well settled. You know, people have been doing something a certain way for a long time. And then someone comes to me and says, well, I have a better way of doing this, or I want to add something and make it more useful. And that's pretty interesting, because you not only, I mean, I don't know about every invention that's out there. So once a client comes to me, I need to learn about that field a little better so I can understand it, understand the improvements, and then write out the application to explain it to basically the world. That's what a patent is. You're explaining to the world how it's done, and in response, or in return, you get about a 20-year period of exclusivity.
It's interesting. One of the guys that I used to work with many years ago, the last I heard, he had like 45 patents. In fact, his office had copies of them that he had not pasted on the walls, but all over. And he never finished high school. It was in the oil field industry. But he just had that creative mind that says, okay, if I do it this way and build this. And so he came up with just a pocket full of ways of doing things, got them patented. Obviously, the company paid for it because it's pretty expensive. But I remember him having more than 40 years, if that's right. No, he was under 60 years of age. We had a major layoff in the company. They let him go. I think he was 57, 58. He had 40 years with the company, or maybe more. And you would think all those patents and everything else would help save you a little bit. But, you know, when the business is tanking and you got to pay people money, things go. But when I think of intellectual property, I write an article. That's my knowledge of what I grasp, and that's my intellectual property. I write a book. I have but if I want to protect it in a way, I do a copyright. And for me, that's just copyright 2024, Red O'Laughlin, or my business name. Is that basically the legal protection I have, just posting a copyright?
Well, what's interesting about the different forms of copyright, different forms of intellectual property, are how you obtain the rights. Exactly what you said with the copyright. As soon as you put pen to ink and come with that creative work, something that you created, like a book, a poem, a song, a photograph, you have a copyright. That's yours, and you own it. When you put the little symbol with the C with the circle in it, that's telling the world that this is yours and you have a copyright. However, to get the full protection of it, you would want to register it with the United States Copyright Office, because once you have a registration, it's actionable, which means if somebody posts your photo on the web, you can take actions to have them take it down. I mean, if you don't have the registration, you can always call them or write to them and say, hey, I have this copyright, please stop. But there's no way to make them stop until you have that registration. So that would be an important step.
Okay, I worked for a company for a while that, in the job I had, my job was to take notes of the discussion for new product development. And the understanding was that if something happened, the notes are there, there's a date on them. And if the discussion of why we decided to do something a certain way and the other people in the room, that was some level of protection, saying, we came up with this idea this day, this month, this year, and here's our proof of doing that. Is that a fairly satisfactory way of documenting it?
I suppose it depends on what you're protecting. Like in patent law, let me back up a second. So like I said about copyright laws, you have it once you put down the idea in tangible form. In trademark law, once you start using a company name or logo, that's your trademark. You start building rights in it. But a patent, you don't really have the rights in it until you obtain that patent. It's a little bit iffy in certain circumstances, but generally that's the case. You don't have the rights until you get the patent document from the United States Patent and Trademark Office. So documenting the steps of when you have the ideas, when you started developing the inventions, is an important step of the process when determining how far back your rights go if there's some sort of dispute. And this is getting into some of the hairy parts of patent law. But I can see a point where if you're developing a copyright or a trademark matter, and in your meetings you're discussing how it's being developed and everything, you might need that evidence if you need to prove that you're the one that created it rather than somebody else. If you both come out with something at the same time, and yours was you saying, I started building this, we started documenting this other person may have had access to that at some point and seen what we were doing, and we can show on the date this person visited, and then there's a dispute where you came up with the same work, same art, the same design, where you can then prove that it was your design and this other person didn't come up with it themselves.
Okay, I got a call from a lady a couple, 3 nights ago. She was my customer 5 years ago. I published her book. And one of the comments that she said in passing was, somebody selling my book in England and I'm not getting any royalties from it. And I said, interesting. I said, I have no idea what the English law is, how they're getting your book or anything like that. But obviously other countries, I'm sure, probably recognize U.S. copyright law. I said, just like we have a copyright office here, go on Google, find out what it is, see what options you have. But that's not something you would take over as a lawyer when you have a conflict for the different country, is it?
Well, what's nice about copyrights is there is international protection if you have the U.S. copyright because of international treaties. It's not necessarily the same with patents and trademarks, where you have the registration or the right is jurisdictional. I mean, if you have a U.S. patent, it's not enforceable in another country, but a copyright would be. But to your point, since I am a U.S. attorney, I would not be taking action in England or any other country, but I have relationships with attorneys in those countries. So if you came to me, I would reach out to them and find out what they would be able to do in their country, because they're familiar with the laws. They have whatever kind of exams or whatever they needed to pass to be registered in those countries.
Okay, I have a slight clarity issue in my mind. I know what a copyright is, I think. I see the registration mark, sometimes a little RM above something. I thought I used to know what a trademark was. I know what a patent is, or at least I think I do. But those are 4 different words, but they all have some level of protection. So if somebody was trying to protect some intellectual property of some sort, what is the level that provides the least to the next, if we're looking at, okay, I really want to protect this, Larry, tell me how I do it.
Can you rephrase that question? I wasn't sure exactly.
Between a copyright, a registration mark, a trademark, and a patent, what level of protection do they afford the owner of that intellectual property?
Okay. I'm not really sure what exactly you're asking.
Okay, what's the difference between a registration mark and a trademark?
Okay. So I'm not sure what a registration mark is. That term. So there's a trademark and a service mark, and most people just call those trademarks, even though there is a slight technical difference. A trademark is technically for goods. You're selling goods, and a service mark is you're selling services. But the term trademark covers both. A registration mark, I mean, there's like an international registration when you're talking about, well, obviously international.
No, on a copyright, I have a C with a circle around it. With the registration mark, I have a capital R with a circle around it.
Okay, so so circle R is a registration of a trademark. So that's when you're using your name and company, you put up a sign above your business, that's your trademark. You start using it. But to register the trademark is to file the papers before the United States Patent and Trademark Office, and they'll examine it for certain necessities. And if it passes, you'll have a registered trademark. Then you can start using the circle R. Before you have the circle R, you can always use the TM. If you've ever seen superscript TM together in capital letters, that means that you're using it as a trademark, but you don't have a registration. Once you get the registration, you can use the circle R. Now, a copyright uses the circle C. Okay, so I'm understanding better now. I have a circle C that I can define myself and go get protection from the government.
I
Yes.
have a circle TM, which says I intend to take this to another level, but the circle R actually gives me a little bit more legal protection.
Right. Because the federal registration does give you several benefits in that it's much easier to protect if you wanted to go to court. It has some sort of assumption of validity. It gives you rights before customs. It gives you federal notification of other people that you're using that, not to use something similar. So there are benefits to it.
Okay, so if I just, Red O'Laughlin, like my MRO Global, that's my LLC. I don't have a reason right now to have a registration mark on it, but at some point in time, if I wanted to, I could go to a Larry Rosenthal and say, "Hey, Larry, what do you think about me registering my LLC?" And you'd say, "Well, tell me why you want to do it," and other questions, and then I would have a decision to make. Do I want to spend the money and do it, or does it even make sense? Is that a reasonable way of saying?
That is a reasonable way. What I like to work with clients and talk to them about is exactly what you asked. What you said is, why do they want to get this registration, or what is their purpose? What are they trying to do? And then I can come up with suggestions to get them there and not waste money. I mean, there are a lot of things you can do. If you're in a certain circumstances, you might not want to do everything. You can do certain things that give you the biggest bang for your buck. Some companies have deep pockets, want to do everything. Most of my clients don't want to do everything because they're, like any business owner, concerned with their cash flow. So I try to advise them on which actions to take that will get them the most protection.
Okay. In the process of publishing a book, another option is called a Library of Congress control number. Is that something your business does?
And then there's the ISBN number, Library of Congress number. I haven't dealt that much with them. I have come across and I have helped clients, but if that issue comes up, it's something I would learn more about. But mostly I focused on other parts of copyrights, trademarks, and patents.
Yeah, my clients typically will copyright their own material and publish it themselves. I give them that opportunity to, if I was publishing Larry Rosenthal Publishing Company,
Right.
copyright whatever date it is and location, etc. Some want the LCCN, the Library of Congress control number, and some will actually take the time and trouble to go and register their copyright. I think I've had one or two people do that over the last 10 years. And so I know there's different levels depending on what the book is and other things associated with it. So there's some levels of protection of that intellectual property within the scope of a book. Now, I know a book is totally different with regard to how it's looked at legally. And I'm me taking somebody's, let's say you have a book and I extract out a small paragraph and I want to use it to either edify you or use it in comparison to something else. But if I want to take song lyrics and do something even remotely close to it, I'm in a totally different world. I don't even touch song lyrics anymore because I know that they're a much more dangerous piece of intellectual property. Have you had any singers or anybody like that that's protected their intellectual property from a music or from a word perspective?
I've done it on the more basic level as far as copyrights, maybe obtaining the registration, but I haven't been in too many disputes with those types of matters. I mean, I was in one large copyright dispute, which was kind of fun. It was actually against Lego, which was quite the eye opener going against such a large company, and that was fun because it dealt with so many different issues. But like I said, I don't really deal that much with the individual artists and things except on the basic level.
Interesting you mentioned Lego because that's one of the questions I have on my list of things here, my little bullets. I think it's Murrieta, California, recently was using Lego faces, and when people were standing in a lineup, you would have 4, 5, 6, 7 people, and each would have a different Lego face. And so when you see somebody and they're filmed out with their car, like as a DUI or something, there would be the person standing there, and there would be a Lego face on the person of interest, for lack of a better word. And this caught all sorts of attention about a week or 2 weeks ago. And all of a sudden, I think it was yesterday or maybe the day before, but very, very recently, Lego said cease and desist. We don't want our product being shown in this manner. And of course, the company came back and said, "Yep, we'll cease and desist." And so, when something is used like that, a cease and desist is the first measure that's taken.
It most times is. Sometimes companies will be really aggressive and just file a lawsuit, but that's not necessary in so many instances because it's much more expensive. A cease and desist letter usually gets the word, and it gets the to the people who are doing it, that they see that Lego is interested, and if they don't stop, they're going to bring their $1 billion behind them to make you stop. So it's sort of just like I don't want to say friendly, but it's a more civil way of, maybe an easier way to end the dispute.
I publish a lot of blogs. With every blog, I always try to publish, without fail, a photograph. And I'll go to the free sites, royalty-free sites that afford me some level of protection, that I'm offering something there in my photograph that is available to the public for free, royalty-free.
Right.
Lo and behold, I published something years ago. Actually, it was a ocean-going ship. And I'm talking about a Navy adventure I had a long time ago, probably just right after Vietnam or something. I can't remember. Anyway, I have the ship there. And I get a letter from a New York law firm saying, "That's intellectual property of my company," or whatever it was. Please remove it. And so I did the same day. I pulled up another one. And it got me thinking, because I couldn't believe that I would actually take a photo from a non-reputable source. And so I went ahead and I sent an immediate response back to the law firm saying, "Okay, I did what you asked for. That's been removed." And so then, my own due diligence, I said, "Let me go find out where I got this thing from." And sure enough, I went back to the particular website that I get most of my free photo. And sure enough, that exact same photo, royalty-free photo, is sitting there in their archives of everything. And so I went ahead and I copied that information. I sent it back to him. I said, "Your client may have to go to this other one because right now it's being advertised as royalty-free." And so I thought that was kind of interesting. That's the first time and only time I've ever been involved in any kind of minor dispute.
That is pretty interesting, because maybe they don't have the rights anymore. Maybe the photographer sold it to this company who gives away the royalty-free use, and then the law and didn't notify somebody else, maybe sold it twice. I mean, it could be a whole entanglement of messy stuff, but maybe this royalty-free site didn't even have the rights. It would be interesting to know how that came about. A lot of times where I see these sort of things is people use pictures because they think you can just grab a picture from anywhere, put it on their website, and then they get these large companies that just go after people and ask for a few $1,000s. And it's a pain in the butt, and I don't think it's needed, but it's a way of somebody making money.
There are some things that people use over and over and over again. It's just, that's the way we've always done it. There has to be some level of difference or uniqueness. In other words, if I want a recipe for a pie crust, everybody makes a pie crust the same way. Now,
Right.
if I add a little bit extra something that's not in a typical pie crust, I might have something that I can do. But when I start putting out a cookbook and I'm using recipes that are so similar over the years, but that's the way my mom used to do it. My grandmother made it this way. How do I ensure that I have some level of protection?
You can't really. Recipes can't be protected that way. What you can protect is if you put a book together, you have the copyright on the entire book. It's the collection, the design, how you picked out the layout and everything. So the artistic aspects of the book. That's why if you ever see a web page with the recipe, it's not just they don't just list the recipe. It's pictures and videos and all this stuff you have to read through just to get the recipe, because then they're adding their artistic comment, and you can protect that to some degree.
Okay. Um, the news had this thing, I guess, probably a month or two back. Harvard, I don't know, it was a dean or whatever, had some issues with plagiarism, and it doesn't matter whether it's Harvard nowadays. We're going to get into artificial intelligence, but people publish stuff, and okay, well, you took 90% of it from this other source. Is there a percentage that says at some point in time you plagiarized? How do you define I plagiarized or I didn't plagiarize?
I don't really have the answer to that one. I know copyright and plagiarism is there's a line there, but people just think of plagiarism as just taking whatever somebody else wrote. And I guess even if it's not even if they don't even have a registration or enforce a copyright, from academic standpoint, plagiarism is a no-no, and that's going to stop people from taking other people's work. So whether there are legal rights or not, it's still just an academic, faux pas.
Yeah, and I think the big deal was there was no attribution to the person who either wrote it or said it or whatever. I think if they had said, okay, in the footnote, this was done at, whatever, I think that would have probably have resolved the issue up front. But when you take somebody else's intellectual property and you assume it to be your own and you publish it, that's where I think the intellectual property violation occurs. Our production engineer has a question or a comment or something here. We've been chatting back and forth, so I'm going to let her come in for a brief moment. Okay, here we go. On the footer of most websites, there's a copyright with the current year. What kind of weight does that hold? And is it worth it to have it there, legally binding, etc.?
Right. I think we touched on that a little bit, is that you're allowed to use that C symbol for anything you create. So you create the web page and you can put the C, and it's a good idea to put it there because it shows that you're the owner of that web page. You put the year, put the name of the company or your name that you created the website, and the content on that website to some degree is you're considering to be your copyright. If you wanted to get that further protection, you could register certain aspects of a website. There are a lot of aspects of a website you can't register, but any wording content, any original photos, things like that, those can be copyrighted, or let's say registered as a copyright.
In networking, we hear a term used a lot that may or may not have some level of intellectual property, and that's branding.
Mm-hmm.
Is that really an intellectual property issue, or could it be?
Well, that certainly is. Yeah, that would fall into the trademark part of brands, and what I offer is brand protection. Is if you have your brand, what is part of the brand makes it important? Somebody recognizes your brand. They recognize your name. They recognize your logo. Some other aspect of it could be a sound. It could be a smell. And that's your trademark. When the public, the consumers see a product or service with that trademark, they expect a certain level of performance or the level of quality of a good. And they know it. Let's say they know it to be good, or they could know it to be really bad and try to avoid it. So hopefully it's good. And that's why it's important to protect. Now, what you're protecting is from other companies coming up with a very similar name or something that's going to confuse people into purchasing their product instead of yours. And that's where you need to enforce your trademark rights to make sure there aren't these other companies with very similar confusing names. So what happens when clients come to me, or before they're clients, they become my clients, is they'll come to me and say, I've been doing this sort of service, landscaping, let's say, for several years. And now I just got a call from somebody saying they're really angry that I messed up their lawn. And I don't even know who that person is because I didn't do their landscaping. It turns out this other landscape person used a very similar name or maybe the same name, did a bad job. And now the client is getting the bad review or the anger leveled at them. So where I come in then would be to make sure that their trademark is protected. And then, as we mentioned before, a cease and desist letter would really be the first start. Is to send a letter saying my client has these trademark rights. He's put a lot of built this goodwill over the years, and you need to stop using it because you're confusing people.
I remember a long time ago, decades ago, that McDonald's had an issue with another company that was using McDonald's that apparently had been in the business because that was their last name, and they had a store with that name before McDonald's even became an entity. I don't know how that was ever resolved in court, but I remember that particular discussion that McDonald's got big enough that they felt like that was their brand and that's what they wanted to own. But
that raises an interesting point. Is that a trademark is in conjunction with a certain good or service generally. For instance, there can be Dove soap or Dove chocolate, two distinct companies, two distinct products, but they have the same name, Dove. So the reason this is allowed is because trademark rights are two things: is the name or logo, the trademark, and the product or service together. However, there's an exception to that rule when something is super famous. If there's a name like McDonald's that's super famous, they might have more rights into other areas. It's a fine line and it has to be analyzed legally, but generally they'll be afforded more broader protection for their name. And what's interesting about what you said is if this other company had been using it, even if they were selling hamburgers, let's say they're doing the same thing, but they have started before McDonald's, then you get into the dispute of who did it first. Not only that, but where were they using it? Who had the federal rights? Who had the local rights? It can get pretty, you can dice it up geographically pretty easily. That's the benefit of having a federal registration. It gives you rights across the country rather than just in your local market.
Okay, we have a few minutes left here before we get toward the end. I wanted to cover artificial intelligence and social media. So I think maybe the easiest one is the social media. Is there any special things that we as just typical users of social media should be aware of? I mean, I get these things periodically say, this went against our social platform or whatever, but they never show you what it is. So you have no idea what you violated. But we copy and we post a lot of stuff out there. Is there some things that we should really be extra careful about with regard to social media in general?
It's too easy to just grab something off the web and repost it. And if you do that, you could be violating somebody's copyright. Some people want you to post their material, but some people don't want it. They want the rights to be able to distribute any material they have. So you could be infringing on their copyrights. That'd probably be the main I can think of offhand, but social media can be protected in the same ways. If you have a brand name on social media, it could be your handle or whatever. If you're using that as your trademark, then you can protect it the same way. The problem with a lot of these social media sites is it's difficult to work with them. Like you intoned, is that if you get this letter from them saying you violated their terms, but you don't know why, sometimes you're really just kind of out of luck. Because they don't tell you why, and they have all this red tape to go through to try to find out, and it's a headache for a lot of people.
I remember when I first started blogging, my goal was 365 blogs in a year. I got to day 300, and all of a sudden, my website didn't exist anymore. It disappeared, and I got this notification saying I violated the fine print of their whatever. And I read through there, and I still couldn't figure out what it was. So I ended up creating another website. I still ended up with 365 in a year, but it was one of those ones that, for whatever reason, I'm doing it, everyone else is doing it, and for today, and I could see, yeah, if you look at it this way, I probably did violate it. Yeah, but that wasn't the way that it was being taken most of the time. So live and learn. And if that's all I did was lose 300 blogs, no big deal, but it taught me make a copy of everything I ever do, and I've done that ever since. But it's interesting.
And this is where, like I was saying, if you would come to me, right, and I charge hourly generally, or maybe a flat fee based on that, and you wanted me to look into why your blogs weren't being published, and you wanted me to approach the company, that could take a few hours of work, and I might be able to resolve it for you. However, probably a lot less expensive and a lot less a headache for you, like you did. come up with this alternate solution. So I would have discussed that with you and said, I don't know if you want to pay this, if you can easily just circumvent that and work around it and just post them on another website.
Okay, artificial intelligence. I've been hopping around that bush here for a little bit. Tell me from your perspective, how does that help or hinder what you do?
It's so new that I can't really give you a final answer on this. It's, let's say the generative aspect of AI is new because there's always been this, not always, but for several years, there's been AI assistants that a lot of programs are using to behind the scenes. But the generative AI is what's getting all the attention now. It's when the ChatGPT and Google Bard and those is when you say, you know, write me something about this in this voice, and it spits out, and you can just take that. And what's really interesting about all these different legal aspects is each form of IP, the office is struggling and dealing with this. In the patent office, they've already ruled if something is completely AI generated, it's not patentable. Patent has to be a person that invented it. In the copyright space, the Copyright Office will actually have a little space for you to write in, this aspect of it was generated by AI. If it was completely generated by AI, you can't get a copyright registration. But if it's still iffy, but if most of it was made by human, let's say you took AI and you enhanced it, or AI did one little part of it and you did the rest, then, or you did it and the AI just kind of enhanced it a little bit, you could get a registration for that. But it's still so new. They're still developing these laws. And now, as far as a practitioner, I saw a case where there's some attorneys got into trouble by having AI write their legal brief. And the AI generator made up cases and cited to them. And the judge found out that they couldn't find those cases. They didn't exist, and sanctioned those attorneys. So you really have to be careful with the tools you're using, that if you use AI to assist you in writing something, you need to fact check it. You need to make sure what it's saying is correct. And it could be a useful tool to help out. I haven't been incorporating it in my practice yet. I enjoy doing the research and writing, but I'm sure as it develops, I'll be leaning on it to some extent. Like, let's say if I need to find a certain case to back up a certain aspect of legal theory, even some of the research companies are starting to use AI, where instead of me doing the search in a certain old-fashioned way, the AI might make it easier to fashion a search strings, or to go out there and do a more robust search than I could just do myself from what I've been doing. And then the results will be enhanced, and maybe it can summarize the results and give it to me in a cleaner aspect. So just sort of envisioning how it can be helpful. I know it's been helpful in a lot of people's lives, just to giving them a starting point, maybe, hopefully not just to replace what people do. So I think people's ideas and inputs are still important. Maybe someday I'll be so good we don't have to do any work, but we're not there yet.
We're here toward the end of the show. We kind of understand what you do, but why don't you go over very briefly, who's an ideal client for you? How do they get in touch with you? And we'll go ahead and wrap up the show.
So my clients I mostly work with are small companies or solo inventors. I do have some clients that are larger, mid-sized companies, even some large companies. Those are harder for me to find as a solo attorney. So maybe a little background about me is that I opened my own law firm about 4 years ago after being in big law in New York and some smaller firms, and then getting a good background in intellectual property. I opened my own firm to be closer with my family, who during COVID little kids are out of school a lot. So you need to spend the time with them. So this is why I opened my own firm, and that gives me the flexibility to work the hours that I need to work and still have proper, time with the family. So that's where I come from for there. So I think what I gain a lot of ground with small companies and solo inventors is because I'm kind of like them, right? I am a small company. I am a solo, and we have that in common, and I can relate to people. I'm also more available, I think, than larger firms. They call me, get me on the phone. We can talk about the issue. and you don't have to go through different levels of secretaries and stuff to try to get time on my calendar.
Okay, and how do people get in touch with you?
So my website is rosenthal.law. It's not .com or anything like that. It's www.rosenthal.law. And from there, you can find an email address, a telephone number, and just reach out to me. And,
okay, for our audio audience, for our audio audience that's listening to this program, Rosenthal is ROSENTHAL.law, LAW. So ROSENTHAL.law, LAW. Larry, really and truly enjoyed it today. There are opportunities come up all the time as things develop over time. I've had guests come back. So depending on what happens down the road, I'd love to have you consider coming back on the show and on the USA Global TV and Radio Network. There are many, many shows that you would probably fit into. So anyway, I welcome you to check it out and see what might be an opportunity there, because I thought we had a really good show today as far as, what is IP and how can I help you? And so I really and truly appreciate that. Thank you.
Well, I appreciate the opportunity to be on your show, Red. It's always been a pleasure talking to you.
Yeah. Take care, and we'll be in touch.
Thank you. You too.
Bye now. red.olaughlin here. Very briefly, it looks like about 15, 16 minutes on the USA Global TV and Radio Network. My next show is called Talking Heads, and I've been on a STEM, not P, not STEP, STEM. Usually we think of science, technology, engineering, manufacturing, but I'm using STM in part of my health and wellness, where I'm looking at stress and toxins and emotions and mental, as far as how do they affect you physically, how do they affect your long-term health and retirement. And so we've talked about stress, we've talked about toxins. Today we're going to be talking about emotions, our emotional health. So please join me on Talking Heads on the USA Global TV and Radio Network. And as always, it's available on YouTube and many other sources. So take care, and I will catch you next week. And thanks again to Larry for joining us today. Bye now.
Women of the Caribbean and around the world, are you tired of the status quo? Tired of barely making ends meet? Tired of giving maximum effort for minimum results? Are you in need of change, a fresh start, a new outlook, a new perspective? It's time to break through. Join us along with women from around the world at the Empower Her Escape, a 5-day all-inclusive royal cruise to the Bahamas and Florida. Connect with world leaders and influencers and begin afresh your journey to more. Hear dynamic speakers with sessions on women in leadership, the importance of mentorship, how to start a business from the ground up, financial literacy, an integrated approach to wellness and wholeness, and so much more. Guest speakers include First Lady Anne-Marie Davis of the Bahamas, Her Royal Highness Katerina of Yugoslavia Lady de Silva, Her Royal Highness Queen Sekothali Mephena of South Africa, and Coach Max, Global Multi-Six-Figure Wealth Coach. Cruise packages include 2 nights at an all-exclusive resort, gratuities, taxes, and port fees, red carpet welcome and extravaganza, course materials, and a souvenir gift bag, flight not included. The Empower Her Escape Cruise takes place on May 15th through the 19th, 2024, departing from the port of Palm Beach, Riviera Beach, Florida. Hosts for this life-changing event are Coach Cherish Hollingsworth of Florida and Coach Mercy Gilbert of the UK. For more information, visit our website at www.empowerherroyalescape.com or call us at 954-203-6608 or email us at cherishresiliencecoach@gmail.com. Connect, collaborate, celebrate at the Empower Her Escape Cruise.
USA Global TV and Radio proudly presents our partner and sponsor, Mr. Philip Sykes and the British School of Excellence, building confidence, changing lives. And now, proudly presenting the Polished Professional.
On a transformative journey with the British School of Excellence's comprehensive suite of masterclasses, crafted to elevate your professional and personal life. 8 outstanding modules will elevate you to the next level. Module 1, Exploring Life's Purpose, delves into the depths of self-discovery, guiding you to chart your unique path to fulfillment and success. Module 2, Mastering Professional Presence and Confidence. This masterclass is a deep dive into the art of self-assurance and commanding presence, which is essential for standing out in today's competitive landscape. Module 3, Learn the secrets of visual impact, how to curate a personal style that amplifies your professional brand. Module 4, Mastering Professional Etiquette and Communication Excellence, navigating the nuances of corporate interaction with grace and tact. Module 5, Elegance in Eloquence. We impart powerful techniques to captivate and persuade any audience with your oratory skills. Module 6, Unlock the potential of your emotional intelligence, EQ, and harness the ability to connect, empathize, and lead with emotional savvy. Module 7, Mastering DISC, building a gateway to understanding behavioral styles, fostering better personal and professional relationships. Module 8, Mastery in Dining Etiquette, building your confidence to perfect the subtleties of dining with finesse, enhancing your social savviness at any table. Step into the Polished Professional program where poise, elegance, and excellence aren't just taught, they're instilled for life. Join us to redefine your potential and polish your professional edge.
To learn more, go to thebritishschoolofexcellence.com. The British School of Excellence are investors in people. Let us invest in you.